As you can see on the screen, the next expert that we have here in the lineup is very much needs of little introduction, certainly one of the most knowledgeable and cordial individuals that we are blessed to have here in this industry. Tom Hudson with Hudson Cook with our regulatory and compliance updates. So thank you so much, Tom, for being a part of us.
Thanks an awful lot. I appreciate it. Appreciate you lending me your watch. On the way out here, my watch fell apart and the battery stopped working, so I'm stealing Nick's watch to stay on time here. Thanks for coming to the session. I look out in the audience and I see at least 5 lawyers that I know of, maybe more. Any lawyers armed with ripe fruit are requested to leave now. I don't want to see any of that stuff. I went to lunch with some folks who are clients. They are here in Arizona. And I told them that this session is not going to be like stuff I ordinarily do. And I don't know whether I'll ever repeat a session like this or not, but I want to see how it goes. My thought was, you come to these conferences and you talk about A suing B and this particular regulatory agency going after this particular dealer or finance company or whoever. And you spend a lot of time on the minutia of the daily back and forth of enforcement and legislative stuff and things like that. I want to step back and take a much broader look at sort of where we've been and where we might be going. I start off with a typo. That's the 100 Years' War, not the 100 Tears' War, although 100 Tears might not be too bad a description. I think about the fight between the consumer advocates on the one side and industry on the other side. And a lot of people who are relatively new to this fight think that it's a relatively new thing, but it's not. It's been going on for ages and ages and ages. When the soldiers came back from World War II and needed washing machines and cars and all kinds of other things, they needed to buy those things on credit, and that led to a spate of, it led to a bunch of bad acting by creditors and by people who were selling goods, and that led to legislation at the state level. In almost all the states, there's something like a Retail Installment Sales Act passed to protect the people who were buying things on credit, all those folks who were coming back after serving in Europe and Asia. So those laws came along, and then in the late 60s, we had William Proxmire come along. And William Proxmire was a senator from Wisconsin. I have that right? I think that's right. Senator from Wisconsin, and he is more or less known as the father of the consumer protection movement, at least as I learned it in law school and coming up through the ranks of the firms I've been with. He was responsible for the Truth in Lending Act and the Equal Credit Opportunity Act and several other federal initiatives designed to regulate consumer credit. Over a period of time, we came up with the Consumer Leasing Act, Fair Credit Billing Act, a bunch of other federal laws, generally the same idea as Proxmire had. Let's rope these creditors in on a national level and make them toe the line in terms of compliance. Then the next thing that came to my mind when I was thinking about how the fight had gone, I remembered something that took place in my world, not in yours. I go to these American Bar Association meetings. The Consumer Financial Services Committee of the Business Law Section meets 3 times a year. And in the early 90s, there was a debate in Boston between my partner, Robert Cook, and Kathleen Keest. And Robert at the time was a well-known consumer credit lawyer. Kathleen Keest was the consumer credit administrator, consumer credit code administrator for the state of Iowa, and generally had the reputation of being one of the roughest and toughest regulators in the country when it came to cracking down on creditors doing bad. But the two of them butted heads at this meeting in Boston, and the argument was phrased like this. Is disclosure enough, or Robert's side of the argument was disclosure is enough. If you disclose the terms of credit, give customers the right to choose whether or not they will sign up for the credit once it's accurately disclosed, that's all we need. Kathleen said, no, that's never going to be enough. Disclosure is not enough. We need substantive regulation of creditors. We need to regulate what they charge, how they charge it, and their actual practices. And I think it's fair to say Robert won the day with that argument. He won the battle, but ultimately he ended up losing the war. And I'll get into that in just a minute. Actually, I don't have to wait a minute, do I? Because here I've got Chris Dodd and Barney Frank and Elizabeth Warren. And they come along with this idea for the Dodd-Frank Act and the Consumer Financial Protection Bureau. When the idea was first floated in the Dodd-Frank Act to form the Consumer Financial Protection Bureau, my immediate reaction was that Obama didn't have the juice to get it all passed, which is a warning to you not to take your political prognostications from a lawyer, because I was wrong about that. Obama did, in fact, get it passed. So we've gone from the early 50s to the 2011, 2012, 2013, 2014, 50, 60 years. We're, what, 6 decades, 6, 7 decades into the fight. The fight ain't over yet. Better times will come. There will come a time when the creditors will begin to win some, I think. The pendulum will swing back the other way a little bit, but I think not any time real soon. And the pendulum has swung so far in the favor of consumer protection that I think businesses are going to have to fairly dramatically change in order to survive. Now, what's going to drive those changes? Here are the things that I think will drive the changes. We seem not to be able to keep dealers and finance companies from misbehaving. There are federal and state legislative initiatives that are underway. Consumers are ever more educated and come up with with more and more demands and higher expectations. We're having technological advances which permit us to do some things with consumer transactions that we were never able to do before. And good old competition is always there, forcing the players in our area to compete on a number of different levels, including competing on the level of compliance. Here are some examples. These are things recently. A $690,000 penalty for a dealer. That's a New Jersey action. The New York Times ran that inquiry on used car dealers last winter, an expose, and another one in the earlier one in 2014 by, again, the New York Times. A lot of bad press for car dealers, a lot of bad press for automobile finance companies. Federal and state regulations, often this stuff is media invoked. You see these headlines in the New York Times, and sometimes the ink isn't dry before we get a bill dropped in a hopper someplace to try to cure the ills supposedly outlined in the New York Times articles. We have one on buy here, pay here, and independent dealers attacking GAP and starter interrupt devices. The LA Times went after the buy here, pay here industry. Again, went after GAP and starter interrupt devices. The consumer advocates drive a lot of this, and who are these folks? There is an outfit called the National Consumer Law Center, NCLC, in Boston, and I describe them as the people who make the guns and ammunition for the plaintiffs' lawyers, and for that matter, for the state-level enforcement folks. These folks is a think tank of lawyers located in Boston. They put out how-to manuals on how to sue dealers and finance companies. Most lawyers I know who do what I do for a living subscribe to those because you really want to know what these folks are thinking. And we've got a shelf in our law library dedicated to all the sorts of things they put out. As an example, there's a dealer fraud book that's about 2.5 inches thick. You pull it off the shelf, and in the back there's a disc containing all the necessary pleadings and discovery documents and everything else that a dealer who didn't know anything at all about dealer finance would need to file a lawsuit against a dealer. So they are the ones who are arming the folks who are suing dealers and finance companies. The Center for Responsible Lending, they may be for responsible lending, but they're not for responsible reporting. They put out this so-called report called Under the Hood. That's the one that Elizabeth Warren was quoted recently as saying that all these millions and millions of dollars in the dealers' pockets need to be put back in the pockets of the consumers. Very shoddy, spotty research, conclusions that are not supported by the world, at least as we know it. Another outfit, Public Citizen, they put out an arbitration report in 2007. Let me give you an example of why these reports are so screwy. In the arbitration report, Public Citizen examined a whole bunch of arbitration cases and concluded that consumers lost in 94% of the instances where matters went to arbitration. What nobody bothered to think about or point out, and when this hit the mainstream media, none of the mainstream media bothered to point it out, the cases that Public Citizen used when they were examining these arbitrations were cases arising out of credit card accounts. These were credit card banks attempting to use the arbitration process to collect credit card debts. And yes, they were winning 94% of the time against the credit card customers. Well, guess what? When you, when you proceed through the courts to collect those same kinds of accounts, you also win 94% of the time. But nobody suggested that we abolish the court system, but still this Public Citizen report suggests that we abolish arbitration. So the Repo Madness report that came out a little later suggested that we ban self-help repossession all across the country. Probably one of the nuttiest things they've ever put out. I don't think that was going anywhere, but anyway. Consumer demands and expectations. You've heard a bunch of this about this conference. I'm not going to spend a whole lot of time on it. Consumers are savvy. They are on the internet all the time. They, surprise, surprise, nobody likes the F&I process. They like a transparent sales process, a transparent closing process. They like to be in and out of a dealership in an hour, maybe, or some short period of time. And the CFPB Complaint Portal is giving them the muscle to do some things that they otherwise have not been able to do up to this point. Technological advances, one of the things, when I think about what's going on in the world, I think about how on earth the small players, the small mom and pop auto dealers especially, are ever going to survive with the compliance load that the CFPB is putting on them. And one potential way to survive, I think, is to have the compliance baked into other things that the dealers are using. And there are ways to do that, and a couple of examples that I've seen recently. You may have seen the Docupad, if you've been to an NADA meeting within the last 10 years. Docupad is a means of closing a transaction where essentially a consumer sits down at a table that is a huge iPad, and all the documents flow up onto the iPad, and the customers walk through each and every one of them the same way every time, usually with the whole thing being recorded. Another one I've seen recently is a concept called SecureClose. SecureClose uses an avatar to deliver a standard prepackaged closing message to every single customer going through the closing process. A very interesting approach. The avatar's script is approved ahead of time by the lawyers, so the avatar's delivery every time is supposedly accurate and compliant. And you know, my thought, somewhere down the road, somebody is going to marry Docupad and SecureClose, and all the F&I people in the country are going to be out of work because anybody will be able to sit there and walk the consumer through that process. Paperless transactions coming at us about as fast as anything. Social media challenges, we're all dealing with those. The competition, credit unions are active, working their way into the subprime area in a big way. We have internet lenders now that are poaching on the business of the traditional finance companies. Peer-to-peer lending models that are coming into play. Again, kind of out of left field, but that's more competition for the consumer's dollar than we've seen before. We may see other direct lending models that begin to supplant the traditional retail installment sales contract method as the CFPB continues to hammer on dealer participation and other things that go on at the dealership. The consumer creditors, the finance companies, may conclude that a direct lending model makes more sense in today's regulatory world. Okay. They here is the bunch of consumer advocates I was pointing to earlier, a combination of the people I had named and the academics who are pushing the consumer agenda, as well as elected officials like Elizabeth Warren and others who are trying to change the industry that you're in. What do they want? Here are some of the things they want. They want a national finance charge cap. And by the way, I'm not making these up. For every single one of these examples that I'm going to mention to you, it has actually occurred that someone has suggested it or proposed it or built a federal or state bill around it. And I'll tell you in each case exactly where I got the idea. Here, this national finance charge cap was proposed as federal law before the Dodd-Frank Act was passed. There's a new Department of Defense regulation where the same kind of concept has arisen. The next best thing, a usury cap that isn't a cap, we're seeing that in the small dollar area and in the DoD regs. Basically, the CFPB says, we're not going to impose a cap, but if you want to charge more than 36%, then you have to do the following things. And the following things are so onerous that nobody's able to do them. So that's what I mean by a cap that's not really a cap. They're pushing for a redefinition of the APR concept. Until now, it's generally the case that if the customer has the ability to refuse to buy something like a service contract or a GAP or credit life or credit accident health insurance, if the customer can get the credit without buying something else, that something else usually has not been treated as part of the finance charge. The consumer advocates want to change that. They want to make everything that's purchased in connection with the transaction part of the finance charge, the price of all that other stuff. So if there is a GAP product being sold in connection with a transaction, they want to say you add the cost of the GAP product to the otherwise applicable finance charge and recompute your APR. And of course, then they want that limited to 36%. They're pushing for a ban on predispute arbitration. This one's probably a done deal. It looks to me like the Chamber of Commerce is posing a fight here, but I don't think they'll win it. I think arbitration in consumer financial services contracts has about 18 more months to run, maybe 2 years at the most. But we will see eventually an end to the use of arbitration agreements. Actually, the Bureau hasn't said that you have to quit using arbitration agreements. What they've said is that you can't use arbitration agreements that have a class action waiver in them. And there's no other reason to use not much of a reason to use an arbitration agreement unless it does contain that kind of waiver. So I think most people will quit using them. A ban on or severe restrictions on spot deliveries. You may have seen something like 23 state AGs around the country sent a letter to the Federal Trade Commission suggesting that the FTC crack down on spot deliveries and pointing out the ways that they ought to crack down on spot deliveries to get rid of some of the worst abuses in that area. We haven't seen the FTC respond to that yet, but I think eventually they might well do so. Meanwhile, lawyers like me who do what I do for a living are telling dealers, if you're going to do spot deliveries, take a look at that AG letter and build your spot delivery process to mirror the best practices contained in that letter. You'll stand a better chance of having a defensible spot delivery process if you do. You've all heard of this one, the ban on dealer participation, or at least a requirement for flats. Again, Sean, you want to talk about that for a minute? Sean Peterson is the general counsel, new general counsel, I might say, with the NIADA, and he's been fighting this one and knows it well. I'm going to ask him to spend a minute.
Sure. Thanks, Tom. So really kind of hot off the press, there is a bill that we've been working with NADA on to sponsor. It's scheduled for a floor vote tomorrow in the House. The bill would require the CFPB to revoke that March 2013 guidance document and would require the CFPB to engage in a public process, engage in public hearing, public comment, those sorts of things. Now, I'll tell you, I think it's going to pass the House with flying colors. I would be a little bit surprised as we stand here right now if the Senate would take it up. The President last night issued a policy statement that he would veto any bill that came across his desk. But the interesting thing that's going on is more and more, you probably know this much better than I do, more and more finance companies are starting to adopt the concept of flats, but both us and NADA, and I know Jack, your NAF, has been vocal on this as well, that that doesn't eliminate any dealer discretion. We've been trying to work with the CFPB to push back on some of that concept and get them to publicly, I don't think they'll ever endorse the NADA Fair Lending program and process, but to at least acknowledge that it's a viable alternative to some of the things that they're working on. But so far, no luck.
Thanks very much, Sean. Wasn't that cool? You got to come up here and talk, and you didn't have to put on a tie. What a deal. Okay. Continuing down the list, the CFPB does not like discretionary pricing of anything. They don't like discretionary pricing of finance charges. They don't like discretionary prices of things like gap policies and other ancillary products. So what we've been telling dealers recently is come up with a price for each one of the kinds of ancillary products you sell. It's the NADA model. Put the price, have a standard price, and if you deviate from that price for any competitive reason, document your deviation and put it in the file. The idea being to eliminate these disparate impact attacks, not only on the sale of financing, but on the sale of the ancillary products as well. This ban on self-help repossession I mentioned earlier, that's not going anyplace, but I wanted to throw it in, but just to show you how nutty some of the ideas are that are coming from the consumer advocates. That particular one, the ban on self-help repossession, focused on the fact that people had been injured and killed in repossession activities across the country over a period of years, several years. Well, what the study didn't point out was that pardon? Well, half the people killed were repo agents. But the study didn't point out that as a percentage of the number of repossessions in the country, the instance of violence in connection with repossession activities was very, very, very low. That one never got any traction at all. We've had at least one state come up with this idea of the dealer disclosure of the cash price of the car on the car. California now says if you're a buy here, pay here dealer, you post the price of the car on the car. And that's designed to keep the dealer from manipulating the price of the car depending on the credit quality of the customer who walks on the lot. California also has this limit on the cash price. No, I'm sorry, this has been proposed. This is not actual yet. Limit on the cash price of the car, something like 125% of Blackbook. The idea being to keep the buy here, pay here dealers from including in their markup an amount which is a proxy for finance charges, which is how the buy here, pay here dealerships work in a whole lot of states. Those two together would be a real crimp on buy here, pay here, and special finance. Severe limits on GPS and starter interrupt devices. After the New York Times piece last winter, there were bills introduced in 20, how many states?
There's 7 hardcore states going on right now, but
yeah.
Had tangential bills.
Yeah, we fought, NIADA and an industry group affiliated with it fought back bills in a whole bunch of states. We ended up with, as Sean says, 7 or 8 really hardcore states. And in at least a couple of 3 of those states, those bills are going to come back this year, and we'll have to fight that fight again. There are also, just to make things, a lot of telemetrics bills were going around last year. These are the bills that try to regulate what the black box in the car does and what it records before accidents and things like that. These telemetrics bills were, we had to look at them because they use definitions that might be broad enough to pick up the GPS devices we were trying to protect. So we were watching them too, but there was an awful lot of bill activity after that New York Times article. The Bureau at one point said that it was going to make the Fair Debt Collection Practices Act applicable to the activities of first-party creditors. The way the act is written right now, the FDCPA does not apply to a first-party creditor or to someone who acquires an obligation at a time when it's not in default. The CFPB said, we're going to change that. And I scratched my head and thought, well, that's kind of interesting. That's a federal act. How are they going to go about changing it? And they answered that question pretty quickly. They said, well, we think that the FDCPA sets forth sort of best practices, and if you're not complying with those best practices, you must be doing things that are unfair and misleading. So, so they are, I think they're going to get to that point at some point. We're likely to see some sort of regulation dealing with debt collection that mirrors the requirements of the Fair Debt Collection Practices Act. This one's cropped up recently. You may have seen that the business about open recalls on cars, and there has been a hue and cry at the state level for legislation that will prohibit the sale of cars with open recalls. AutoNation has come out and said that it's not going to sell cars with open recalls. It decided to get out in front of that argument and garner whatever public relations benefit it could. If you stop 50 people on the street today and ask them if there was a 3-day right of rescission when they bought a car at a dealership, 47 of them would say yes, there is. People think that's law, but it's not. The consumer advocates know it's not, and they want to change that, so they've pushed in several instances to try to get that changed. They haven't had much luck with that yet. They had an odd version of that put into place in California, but you can buy your way out of it if you're a dealership. And there's a provision of the Connecticut leasing law that gives a 3-day right to rescind. But other than that, there is no 3-day right to rescind in any other any other state that I know of around the country. You remember when the Federal Trade Commission held its roundtables around the country? There were 3 of them, and they would bring in the consumer advocates, and the consumer advocates would sit there and tell all these sob stories about how this person or that person had something bad done to them by a dealer or finance company. Anecdotal evidence. And after every one of the anecdotes was told, the industry folks like me, Sean, would sit there and say, wait a minute. There are already laws that would prohibit whatever you just described. You know, we don't need new laws. We don't need new regulations. We need for you to enforce the ones you've got. Well, better watch what you ask for, because that's what the CFPB has been doing lately. They've been enforcing laws that have been out there forever and ever. The discrimination laws have been around since the, 70, come on, Mark, help me out. ECOA, 70 early, anyway. The ECOA has been around forever and ever. It hasn't been rigorously enforced at all, and that's where the CFPB gets the authority to go after the discrimination claims. The advertising rules, the FTC has had the authority to enforce the unfair and deceptive practices part of its mandate for ages and ages against dealers who were doing advertising, and they hadn't done anything until all of a sudden they look across town and the CFPB is getting all the publicity and being portrayed as the champion of the consumer. So the FTC says, whoa, maybe we ought to enforce some of the laws that we've got. And they went off on a tear and have been bringing actions left and right and sideways against car dealers. Payment packing, I remember a piece written by the Washington Attorney General years and years and years ago on payment packing and describing it as an unfair and deceptive act or practice. Payment packing has been illegal for as long as I can remember. Hidden finance charges. This is one that impacts anybody who's in the subprime area, and it impacts anyone who's doing a buy here, pay here operation. The concern is that if you are a buy here, pay here dealer and you're selling an $8,000 car for $12,000, and some of that is a proxy for finance charge, that you are violating the Truth in Lending Act. Likewise, if you are a dealer and you're selling your paper to a deep discount finance company, and you are increasing the price of the particular car involved in the sale in order to cover the discount you've got to pay to the deep discounting finance company, that, says the CFPB, is a hidden finance charge. We have seen both of those recently in CFPB enforcement actions, and we're going to see more and more of them. They know those issues are there, and they're going to be very, very active enforcing the law. And again, that one dates to 1968. That's a law that's been around forever. Likewise, the Service Member Civil Relief Act, that's a law that's been around forever, and the CFPB now has its own standalone inside the CFPB operation specifically to protect service members. And we'll see a lot of activity in that area, enforcement activity there. You heard of Operation Steer Clear. The FTC seems to have a talent for naming their operations. The steer clear operation, I'm told, was not specifically something they set out to do. It was a whole bunch of actions they had engaged in over a long period of time that the PR folks at the FTC decided they could milk for a little bit of press attention. So they named the whole thing Operation Steer Clear and put together all these press releases talking about how much they had done over such a long period of time. Again, you get back to the consumer demands and expectations. Consumers are on the internet all the time. They are looking for as transparent a closing process at a dealership as they can possibly have. They want to see transparent F&I menus when they go in. They don't want any flim-flam or any bait and switch, payment packing, all that stuff. Consumers are savvy to a good number of those activities. They've seen the New York Times articles just like we've seen them. They want an instantaneous or as close as possible to it closing process. They want to see fair and consistent pricing for the car and all the goods and services, all the ancillary products that go with the car. They don't like doc fees. They think that's nickel and diming. And they want other products, gap and service contracts that they can easily understand and see the value in terms of both the services rendered and the price of those products. And don't forget the CFPB Complaint Portal. I mentioned this earlier. The baked-in compliance stuff is, I think, going to be the answer for small finance companies and for dealers. And if you are buying paper from smaller dealers, I think your finance company will do itself a big favor if it pushes downstream on those smaller dealers and says, look, you need to go and work with vendors and get as much of the compliance as you possibly can baked into your process so that you don't have to necessarily maintain all of the compliance processes and procedures that perhaps the CFPB will want to see in somewhat larger operations. You know, with most of the CFPB's statements, they have indicated that the compliance effort can be commensurate with the size of the operation, the size and complexity of the operation. And if you've got a 5-person buy here, pay here operation, literally mom and pop and a detail guy and a salesman and somebody to carry the books, then you're not going to have the same kinds of resources to throw at these compliance issues as is somebody like Ford Motor Credit Corporation. Seems like every time I go to a conference, I end up getting questions that sound to me like dealers and finance companies, especially small finance companies, are looking for instant answers. You remember your teacher in grade school who says, I can't bore a hole in your head and pour the knowledge in? That's the way it is with the compliance stuff. You can't just bore a hole in your head and pour the knowledge in. It's an undertaking that involves an actual large amount of work. And the dealers and finance companies who are, I commend the dealers and finance companies who are going through the training sessions that Jack is offering through NAF. They are actually engaging in the work necessary to really understand the stuff because that's the level of effort that it's going to take. Dealers themselves may not need everything that Jack offers. They may be able to do just fine with the AFIP training program, which covers the front end of the business and covers dealers only. Any dealer who has a buy here, pay here operation or who wants a deeper understanding of the whole credit process needs to go through the NAF Certification Program. And I ask you now, if I'm running a finance company and I'm buying paper from 200 dealers, seems to me like it would be in my interest to find out if those dealers are actually trained in terms of the F&I laws they need to know. So maybe I need to go out and do a survey of my dealers and say, what kind of training have your folks gotten? What kind of compliance training exists in your operation? Show me the diplomas, show me the certifications of your folks, because I'm here to tell you they're not there. At the dealer level, there's very little training that goes on. My son took a job recently as a Volvo salesman in a Volvo store near Baltimore. And after he'd been on the job for about a week or 10 days, I said, Brad, tell me who your compliance officer is in your organization. And he said, as far as I know, we don't have one. And this was a major new car store. So if a major new car store doesn't have a named compliance officer that the employees of the organization actually know, you can bet your socks that smaller operations aren't going to have those folks either. So if I'm a finance company buying paper from those people, I want to know what the training looks like. And I want to know it's really there. This is just an outline of the compliance management system. The CFPB has announced that everybody under its jurisdiction is expected to have a compliance management system. The components of those, the top one is board oversight. I was talking with my friends at lunch today, and I said to the owner of the organization, I said, do your board minutes reflect the fact that your people are reporting up to you on a periodic basis about everything they're doing to keep the store in compliance? And he said, well, no, we don't do that. And I said, well, that would be a very good idea. And furthermore, it would be a very good idea if you had a requirement for monthly or quarterly reporting by all your direct reports come to you and give you a written report once a month or once a quarter about what they are doing to make sure you stay in compliance with all the laws that apply to them in their particular operations. And all that needs to be folded into the dealership's paperwork. This was a buy here, pay here operation. Needs to be folded into the paperwork so that when the CFPB comes calling, you'll have a paper trail of what you're doing to monitor your compliance. The written compliance program, there are not many of those out there, and there are not many complaint response programs. Vendors are beginning to come online, by the way, to supply some of these things, but not all of them. Yeah, this is the bore a hole in your head stuff. You can't just pull it off the shelf. There's not any plug-and-play stuff here that I know of, very little of it in any event. There's nothing, nothing between you and a complete compliance effort, but just plain old hard work. You have to get down, learn the stuff, slog your way through it, create all the stuff you need to create in order to have the stuff that you will show to the CFPB when they darken your door. And you can't outsource it. You got to do it yourself. You're responsible for everything done in your name. I'll quit preaching. Grew up in the first few years of my life, I was a Southern Baptist until I found out the pretty girls went to the Episcopal Church. So I get preachy sometimes. Questions? Please. Come on, guys. You can do better than that. Yes, yes, sir.
Hey, Tom, one I didn't see on your list, bi-monthly payment products.
Yeah, there's been some enforcement activity on bi-monthly payment products. We have had clients who have offered bi-monthly payment products, and there are ways to offer them that work and ways to offer them that don't work. Sometimes the problem with the bi-monthly payment products is that at least a good number of them soak up in fees more than they'll ever save you, so that any savings is illusory. And the New York Attorney General had a problem with that, and I think it was the FTC that had a problem with it, one of the federal agencies. They don't like the bi-monthly payment products. But it's possible to do them and do them correctly, and it's possible to have, the economics can work out, but you need to be real careful with those, I think.
And it's another one of those products that's not disclosed, right, in the contract?
Well, typically the way those, at least I understand the way most of those products operate, is that the transaction, the customer and the dealership engage in a retail installment contract, and the retail installment contract sets out when the payments are due and the amounts of the payments. And then when that transaction is done, the dealer then says to the customer, by the way, if you would like to pay down your obligation sooner, I've got this bi-monthly payment product thing. The customer's contractual obligation has not changed. And you make your truth in lending disclosures based on the customer's contractual obligation. So it's not a matter of having to give new truth in lending disclosures or anything like that. The customer and the bi-monthly payment folks enter into an agreement to have the bi-monthly payment folks make the payments. So supposedly it doesn't show up on the contract. Now there may be states where there are state laws that, single document kinds of laws that might cause you to do that a little bit differently. Yes, yeah, Paul.
Over the markup and being limiting it, call it 100 basis.
Yeah.
Somehow improve or affect or get rid of disparate impact in effective classes 20 or 30 basis.
Yeah, the tighter, the thinking behind it is, did everybody hear the question? The question was, what's the rationale behind the recent settlements where there has been a cap on the number of basis points that dealers can mark up a retail installment contract? And the idea of the CFPB is to keep on squeezing that cap. They think that the narrower they can make that cap, the less likely it is that there will be discretionary pricing that will be discriminatory. That's the thinking. And I think your comment is, well, wait a minute, you still got a 100-point spread, and they've been prosecuting people for 20-point disparities, right? So there's still plenty of room to do some bad stuff in there, and that's probably true. Yes, ma'am. Is the CFPB pushing reverse discrimination? I don't know. Explain that.
Well, because they are saying, well, this market, with this last name and this zip code, you have to be more careful of how much you're marking their rate at, as opposed to, but we don't have to worry about somebody that comes in looking like you, will laugh in the head, and not have to.
There are plastic surgeons available if they look like me.
That's literally what's happening.
Yeah, well, that's an interesting viewpoint. I hadn't really thought about that.
That's literally what's happening in the dealership.
What she's saying is true. The only way that you get to pass a CFPB audit is to discriminate against everybody who doesn't have
It's not a minority.
Hispanic surname.
Yeah.
That's the only way you're ever going to get the statistics.
There are a bunch of youngsters who work at the CFPB, and I have a lot of fun jerking them around occasionally. And one of the things I tell them is that, discrimination is not illegal. Credit companies are in the business of discriminating. That's their job. They're supposed to discriminate between people who cannot repay or will not repay and those who will. That's their job, discrimination. The only discrimination that's illegal is discrimination that's made illegal by a state or federal statute. So discrimination as such is not a bad thing. And they look at you with this funny look on their faces. Yes. Anyone else? Before I quit, I will say I'm going to be around for the soiree tonight. I welcome anybody who wants to come and visit and talk about legal stuff. I have a lot of fun doing that. And I'll look forward to seeing you all there. And thanks a lot.